your ass, you dumb bitch. Put my hand in your mouth again. What's wrong with you? You're fine. Good morning. Happy Wednesday. Hope everybody had a good night. I'm looking forward to these closing arguments this morning. I thought the trial yesterday was a little crazy.
rise in the jury. Please have a seat in the court. Okay, members of the jury, we have the completed charge of the court. Thank you for your patience. I'm going to read that to you at the conclusion of my reading. You don't need to memorize anything. It'll be back there for you to refer to, but after I'm done, the state and the defense both have an opportunity to argue the case, and then we will ask you to deliberate. This is cause number 2024 CRG 00717D2, the state of Texas versus Billy Delgado. Members of the jury, the defendant, Billy Delgado, stands charged by indictment with the offense of aggravated assault causing serious bodily injury with a deadly weapon to a family member, a felony of the first degree alleged to have been committed on or about the first day of June 2024 in Webb County, Texas. The defendant has pleaded not guilty to these charges. Assault is defined as a person commits the offense of assault if he intentionally, knowingly, or recklessly causes bodily injury to another. Aggravated assault, a person commits the offense of aggravated assault if he commits assault as hereinbefore defined and he causes serious bodily injury to the injured party. Bodily injury is defined as physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. .022 and 573.024 of the Government Code. Individuals who are the former spouses of each other, individuals who are biological parents of the same child without regard to marriage, and a foster child and foster parent without regard to whether those individuals reside together. Dating violence means an act by a member of the family or household against another member of the family or household that is intended to result in physical harm, bodily injury. Assault or sexual assault, or that is a threat that reasonably places the member in fear of imminent physical harm, bodily injury. Assault or sexual assault, but does not include defensive measures to protect oneself. Act means bodily movement, whether voluntary or involuntary, and includes speech. Conduct means an act and its accompanying mental state. Individual means a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth. Intentionally, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. Knowingly means a person acts knowingly or with knowledge with respect to the nature of his conduct or the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person is aware of but consciously disregards a substantial and unjustifiable risk that the person's action will cause bodily injury to another. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Count 1, application, aggravated assault causing serious bodily injury with a deadly weapon to a family member. Now, if you find from the evidence beyond a reasonable doubt that on or about the first day of June 2024 in Webb County, Texas, the defendant, Billy Delgado, did then and there intentionally, knowingly, or recklessly cause serious bodily injury with a deadly weapon to a member of his family, to Erica Edith Torres, herein styled the complainant, by shooting at her person, and the defendant used or exhibited a deadly weapon, namely a firearm, during the commission of the assault, and the complainant was a person with whom the defendant has or has had a dating relationship as described by section 71.003 or 71.005 or 71.0021B of the Texas Family Code, then you will find the defendant guilty of aggravated assault causing serious bodily injury with a deadly weapon to a family member as charged in the indictment. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. Justification, defense of a third person. A person is justified in using force against another to protect a third person if, number one, under the circumstances as the actor reasonably believes them to be, the actor would be justified in using force to protect himself against the unlawful force he reasonably believes to be threatening the third person he seeks to protect, and number two, the actor reasonably believes that his intervention is immediately necessary to protect the third person. A person is justified in using deadly force against another to protect the third person if, number one, under the circumstances as the actor reasonably believes them to be, the actor would be justified in using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect. Number two, the actor reasonably believes his intervention is immediately necessary to protect the third person. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. The use of force or deadly force to protect the third person is not justified, number one, if it is in response to verbal provocation alone, or number two, the actor provoked the other's use or attempted use of unlawful force, unless the actor abandons the encounter or clearly communicates his intent to do so, and the other nevertheless continues or attempts to use unlawful force against the actor or third person, or number three, if the actor sought an explanation from or discussion with the other person concerning the actor's differences with the other person while the actor was unlawfully carrying a weapon, a person who has a right to be present at the location where the force or deadly force is used, who has not provoked the person against whom the force or deadly force is used, and who is not engaged in criminal activity at the time the force or deadly force is used, is not required to retreat before using force or deadly force to protect a third person. In determining whether the actor reasonably believed that the use of force or deadly force was necessary, you may not consider whether the actor failed to retreat. On the issue, when the issue of the application of defense of a third person is raised, the burden of persuasion is on the prosecution to disprove the justification beyond a reasonable doubt. If you have a reasonable doubt as to whether the defendant's conduct was justified by the defense of a third person, you must find the defendant not guilty. Application of the law of the facts in that regard, you must determine whether the state has proven beyond a reasonable doubt that the defendant, Webb County, Texas, on or about the first day of June 2024, intentionally, knowingly, or recklessly caused serious bodily injury, firearm, and or G3C 9mm Torres during the commission of the offense, and that Erica Edith Torres was a person with whom the defendant has or has had a dating relationship. You must agree on all of these elements, but if you do not have to agree which culpable mental state, that is intentionally, knowingly, or recklessly, the state proved. If you find from the evidence beyond a reasonable doubt that the defendant is guilty of aggravated assault as stated above, you must next consider whether his conduct was justified by the defense of Esmeralda Delgado. If you all agree the state has failed to prove beyond a reasonable doubt one or more of the elements listed above, you will acquit the defendant and say by your verdict guilty. If you agree the state has proven beyond a reasonable doubt each of the elements listed above, you must next decide whether the state has proven that the defendant's conduct was not justified by the defense of Esmeralda Delgado. To decide the issue of defense of Esmeralda Delgado, You must determine whether the state has proven beyond a reasonable doubt at least one of the following three elements. The elements are that, number one, the defendant did not reasonably believe his conduct was immediately necessary to protect Esmeralda Delgado against Erica Edith Torres' use or attempted use of unlawful force or unlawful deadly use, unlawful force or unlawful deadly force against Esmeralda Delgado. Or number three, under the circumstances as the defendant reasonably believed them to be, the third person would not have been justified in using force or deadly force to protect himself or herself against the unlawful force or unlawful deadly force of Erica Edith Torres. You must all agree the state has proven beyond a reasonable doubt at least one of the three elements listed above. You need not agree on which of these elements the state has proven. If the state has failed to prove at least one of the elements beyond a reasonable doubt, then the state has failed to prove that the defendant's conduct was not justified by the defense of Esmeralda Delgado, and you must find the defendant not guilty. If the state has proven at least one of the elements listed above beyond a reasonable doubt, then the defendant has proven the defendant's conduct was not justified by the defense of Esmeralda Delgado, and you must find the defendant guilty. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the issue of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or to produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all of the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required, however, that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all of the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. You are the exclusive judges of the facts proved, the credibility of the witnesses, and the weight to be given their testimony, but the law of the case you shall receive in these written instructions and be governed thereby. After you retire to the jury room, you should select one of your members as your foreman or presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as foreman or presiding juror. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. No person has any authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through the officer. Any communication relative to the case must be written, prepared, and signed by the foreman and shall be submitted to the court through the officer. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause and restrict your deliberations solely to the issue of the guilt or innocence of the defendant. Following the arguments of counsel, you will retire to the jury room to consider your verdict, and we will await your unanimous verdict. You have one verdict form attached, ladies and gentlemen. where you find the defendant either guilty or not guilty, please make sure that the presiding juror signs the correct line indicating your unanimous verdict. Ladies and gentlemen, not in the charge, but I just want to tell you orally, every court treats notes differently. I encourage note-taking because if it assists you in concentrating on the evidence, I want you to do it. But it is important you understand that although you were permitted to take notes during the testimony, in the notes with the other jurors, and you should not permit the other jurors to share their notes with you. You may, however, discuss the contents of your notes with the other jurors. You shall not use your notes as authority to persuade your fellow jurors in the deliberations. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and counsel. Notes are valuable as a stimulant to your memory. On the other hand, you might have made an error in observing or might have made a mistake in transcribing what you heard. Therefore, you are not to use your notes as authority to persuade fellow jurors of the evidence during the trial. Occasionally, during jury deliberations, a dispute occurs as to testimony that was presented. In that case, you shall inform the court and request the court to resolve a dispute. If you do have a dispute, specify what it is in writing, and that portion and only that portion will be read back from the official transcript. With that, ladies and gentlemen, both sides have been given an hour to argue the case. Should they elect to use it, the state does have the burden of proof, so they have the right to open and close the arguments. I'll ask them to address you at this time.
Thank you, Judge. May I please the court? Counsel, ladies and gentlemen of the jury. You're free to choose, but you're not free from the consequences of your choices. What did Mr. Soto say in opening statements? This was a case about choices and consequences. And how on June 1st of 2024, that man sitting right there made a fateful choice that has consequences for which he must be held accountable for. Now, what choice did he make? He chose to commit the offense of aggravated assault of a family member with a deadly weapon which resulted in serious bodily injury. Let's go over those elements. You heard testimony when it comes to on or about June 1st, 2024, from the investigators that responded to the case, from Investigator Lopez to Amasquita, Mark Vela, Florencio Barrera, how they got a call and they were dispatched to 2420 North Smith Avenue for a shooting call. You heard the victim, Erica. She took the stand and she told you, she testified that she went to Billy Delgado's residence because he called her over because of some issue with her daughter. Let's move on to the second element. In Webb County, Texas. It happened on 2420 North Smith Avenue. I asked Officer Amasquita and even Erica testified that that residence is located in Laredo, Texas, which is in Webb County. Let's move on to the next element. The defendant, Billy Delgado. What evidence do we have? Well, we saw Officer Amasquita testify. We saw his body cam. You'll be able to take that with you in the back. He confessed. Yeah, I shot her mom, Musrar, Emmy, his daughter, who happens to be Erica's daughter as well. We see Juan Angel Pina surveillance footage, and we see it point blank. Look, it's right there, point blank, aiming a gun right at Erica through the passenger side window. Erica IDs. I heard 3 shots through my windshield, and as I drive by, I see Billy shooting, pointing a gun at me. And let's not forget the forensic scientists that came over and confirmed that there was gunshot residue on Billy Delgado after Mark Vela got samples from his hands and sent it out for testing. But ladies and gentlemen, the most important one, he confessed on June 1st, 2024. He confessed back then, and he took the stand, and he confessed on the stand as well. Check, check, check. All right, let's talk about the next element. Intentionally, knowingly, and or recklessly. Well, it started May 19th, prior to June 1st. Erica and Kayla took the stand, and what did they say? Erica said, on May 19th, almost 2 weeks prior to the date in question, Billy told her, enjoy your birthday, because this will be your last one. Kayla overheard that same conversation and could confirm that's what Billy said. So he had a plan already. He had a plan that he wanted to execute. And execute he did. There he is. Look at State's Exhibit 4. He's laying in wait. Erica's up there. You see her coming in a green Kia Soul. He's laying in wait, waiting to ambush her to execute that plan. And execute he did. What did Florencio Barrera say? In my experience, he was about 5 feet away from her. He didn't fire one shot to eliminate a threat like he's gonna later claim. He fired 10 rounds. He had a purpose. A man with a purpose, walking with a purpose. State's Exhibit 5 will show the other angle of Bina's home surveillance footage. And what is he doing? She pulls over in distraught. He's walking with a purpose, fidgeting with his pockets. Go, look at it. He's fidgeting with his pockets, touching his gun. He goes back to his apartment and he puts his gun. Oh, and what else did he put up there? 2 loaded magazines. He didn't get to finish the purpose he set out for. He gets arrested once Amasquita gets her, and what does he say? I emptied a whole clip in her mother. Again, who's her? Emmy. Mother being Erica. He was in handcuffs in the patrol unit, talking to a neighbor, and you can see it on Amasquita's body cam. And what does he tell this neighbor? What am I supposed to do? I'll just deal with the consequences. He took the witness stand as well, and he admitted yesterday, he took the witness stand and he admitted to shooting her intentionally. Now let me talk about serious bodily injury. Now, you're gonna get the law from the court, which you already did. It's right here. The definition of serious bodily injury is here. Let me discuss it real quick. Serious bodily injury is bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. What did Dr. Mederos come? He came here on his busy schedule and he took the stand. And what did he say? He said that if I did not intervene and do the medical treatment and surgery on Erica, she would have 100% had a chance of dying. That at any time that he was doing his surgeries, his laparotomies as he called it, which he did twice, by the way, to save her, that at any moment she could have died. I asked him on page 17 of the medical records, and you'll have him in evidence, what does hemorrhagic shock mean? He defined it for us. And I asked him, if that were to be left untreated, what could it result in? He said death. That her pH levels are below a certain level, to the point that if somebody has them and if they're not treated, they die. That's what she had. pH levels below the level he described to where she could have died. Ladies and gentlemen, bodily injury that creates a substantial risk of death or that causes death, check. I think we got that. We've proven that beyond a reasonable doubt. But let's continue. He also talked about how, and that's page 17, ladies and gentlemen, on the medical records, they're in evidence, how she lost 4 liters of blood. And I asked him, had they not been replenished, what could have happened, Dr. Mederos? She would have died. And he goes into discussion about, he discusses in detail how much blood she had to be replenished. And it's in the records. He also testified that she's gonna suffer from short gut syndrome, meaning a large part of her intestines were cut out and she doesn't have them. It's gonna affect her ability to get nutrients, to live a long, healthy life, be able to do certain activities that you and I take for granted. She spent 363 days in the hospital. That's close to a year. Losing a large part of your intestine? Let's go back. Protracted loss or impairment of the function of any bodily member or organ. Check. This is how that man left her. This is the picture on the right. That's 4 days prior to today. 4 days, and look how we left her. I believe she even testified that she still had a staple, and you can see it right there. Oh, but yes, she did come in walking normally and looked fine. Okay, yes. Serious permanent disfigurement. Check. I asked Dr. Mederos, are you familiar with the legal definition of serious bodily injury? And he said yes. I asked him, as to all three possible definitions, do the injuries that Erica sustained at the hands of Billy Delgado, would you, in your medical opinion, classify them as serious bodily injury? And he said yes to all three. As a matter of fact, he took the stand up here and he even said, yes, I caused serious bodily injury to Erica Torres. That's another element that we have proven beyond a reasonable doubt. Now who is our victim? You heard it from the horse's mouth. She came up here, she testified as to what she experienced, what she went through, what she remembers, what she didn't remember, not because she was trying not to remember anything, because she literally couldn't remember because of what he did to her. We saw Peña's home surveillance footage where she's driving her green Kia Soul. And how do we know she was driving the green Kia Soul? Because Kayla testified that she drives the green Kia Soul. Kayla also testified that she was on the phone as Billy was raining bullets at Erica. And again, he confessed back then on June 1st, 2024 to Officer Mesquita, and he confessed again when he took the stand yesterday. Another element met beyond a reasonable doubt. Let's talk about the deadly weapon element now. Deadly weapon. So again, you're given the law by the court, by that man right there, the judge. He gave you the law. It's in here. A deadly weapon, we know, automatically, we call it per se in our legal terms, but it's automatically considered a deadly weapon, a firearm. We know State's Exhibit 6 is right here. Y'all can check it out. Y'all can take it back there and look at it. Investigator Juan Lopez sees a black Torres G3C pistol. I asked Lopez and I asked Mesquita, Officer Mesquita, is a Torres G3C pistol considered a firearm? Yes, it is a firearm. It's meant to kill. We look at Peña's home surveillance footage. And actually, I can go back. You can see the firearm he used right there on his hand. Erica described it. And he admits to it too. You can see it on Officer Mesquita's body cam. Where did you put the gun? Oh, and I believe, quote for quote, oh, it's on the chair right there on the black chair. Sure enough, that's where it is, with 2 loaded magazines. And then again, he took the stand yesterday and he testified that he did use a deadly weapon. Ladies and gentlemen, there's another element meant beyond a reasonable doubt. Let's go to the final element. So again, the court has provided you the law. Here's the law. This, it's gonna be right here with you. You take it there and you go read it and you look into it. You base the evidence and see if it matches, if it qualifies. 71.003, family includes individuals who are former spouses of each other or individuals who are parents of the same child without regard to marriage. Section 71.0021B talks about dating violence. So in this case, is committed against the victim, Erica Torres, with whom the actor, that man right there, Billy Delgado, has or has had a dating relationship. Ladies and gentlemen, we heard from Erica. They dated since 2018. They got married on March 21st of 2021. They divorced 2025. In between, June 1st, 2024 is when the actions that Billy Delgado took, that shooting, happened in between. They were married when he committed that crime. Married. So, satisfied. Oh, they both testified. Erica took the stand. Billy took the stand. Yes, we share a daughter, Emmy. So that each amount of evidence, ladies and gentlemen, he confessed back then. He confessed on the stand yesterday. You should find him guilty beyond a reasonable doubt of injury. Now, they're gonna deflect from the situation at hand. And that's that. Not focus on the choice that man made and the consequences that he should be accountable for, but focus on the victim and how she's a bad mother and how she looks fine and how she's a bad person, airing out all her dirty laundry. Ladies and gentlemen, she took the stand herself. She aired her dirty laundry for you. She didn't need them to do it. She went up there and she told her faults. She admitted to them. I also anticipate that they will probably argue that, well, Billy did what he did because he had to defend somebody. In this case, he had to defend Emmy. You're going to go back there and there's going to be a defense of third person. And defense of third person, and again, you have this, it's being to by the court. It says, under the circumstances as the actor reasonably lawful force, he reasonably believes to be threatening the third person he seeks to protect, and important, the actor reasonably believes that his intervention is immediately, another important word, immediately necessary to protect the third person. Okay, so he's trying to protect Emmy from who? This Uncle Louie, who never made an appearance in this case other than just him saying it. As a matter of fact, we brought you Investigator Vaquera. They looked into it, the multidisciplinary team. There was no merit in that allegation. There was nothing there. So why pursue when there's nothing there? They did their job, they investigated it. Protected from him? From Louis? Protect from what? From Erica, because he was gonna take Emmy back to Louis. Well, if I recall from the testimony, Billy was supposed to have Emmy until Sunday. Erica was supposed to pick up Emmy on Sunday. No, he calls her a day before, hey, I'm having issues with her daughter, come get her. So a day before Erica was supposed to have Emmy, he calls her over. So he calls Erica, who may be a danger to Emmy, over on his day where he's supposed to have his daughter. Remember, Emmy was in his apartment eating pancakes that he happily was making for her, playing with toys that he gave her, according to his roommate's testimony. What danger was she in? There was no danger. There was no immediate danger. There was no danger at all. He called her over to execute his plan so that he can ambush her and kill her. And he executed that plan, but he failed. And luckily he failed because she was able to come out here and testify for you and tell her what she went through tell you all what she went through, instead of being 6 feet deep. And Judge, I'm going to go ahead and yield the rest of my time to Mr. Sullivan.
All right. Thank you. That was 18 minutes. Defense.
May it please the court, opposing counsel, ladies and gentlemen of the jury. Let me address you. I'm not going to be yelling at you. I'm not going to be showing you gross pictures to try to deflect you from the issues at hand, okay? So what are the issues at hand? The state seems to believe that it's just an aggravated assault with serious bodily injury. As you see in your jury instructions, you're going to see that it says, when the issue of the application of defense to a third person is raised, which it has in this case, the burden of persuasion is on the prosecution to disprove the justification beyond a reasonable doubt. If you have a reasonable doubt as to whether the defendant's conduct was justified by the defense of a third person, you must find the defendant not guilty, okay? So they're going to try to disprove defense of a third person by argument, okay? Argument. They didn't put up any evidence up there to say that there was not a defense of a third person. They failed. So it's just not to do it. They could have called Uncle Lou defense. It had to be immediate. It had to be an immediate threat. That's why he didn't wait till Sunday. He wanted to take care of it now, okay? If it wasn't immediate, he would wait till Sunday. If he wanted to ambush her and kill her, he would have waited till Sunday. She was going to come over, okay? It didn't flow that way. It doesn't flow right. If he wasn't abused all these years, would we be here? Probably not, okay? So remember how he's been shaped over these years. He threw a weight at him. They hit him several times. She told you she's been arrested for beating up her own brother. And her words are laying hands on somebody. Okay, she got arrested. Okay, Billy says that she's got friends in high places. Nothing happened to her. You know, we talked about second chances. How many chances does she have? Her brother, Billy, several times. She admitted to drinking with her kids in the back seat. One of her kids. That's a felony offense here in Texas. Anything happen? Okay, keeps going over and over in his mind. That's what he's thinking, okay? And it's in the instructions what a reasonable person is, okay? The abuse, psychological abuse, verbal abuse, the physical abuse, it shaped him, okay? I can't get any help, okay? Because of her friends. Nothing's gonna happen. He's had enough. Now something's happened to his daughter, so he's gotta act. And he acted. That's what it was. Now, there is a jury instruction for that. The state can't disprove it that he did it to defend his daughter, okay? She's being abused. They even told you during voir dire, I believe, they said we have a single witness rule. All we need is one witness. The state always does that. Well, in this case, we have one witness of the abuse, and guess what? It doesn't matter. It doesn't apply. It doesn't apply now. He heard it. Did you go talk to the guy that did it? He just got out of prison. If I was a cop, that's what I would do. The guy got out of prison. Let me go see what he wants to tell me. Okay, maybe he'll confess. I don't know. I called him. I couldn't find him. It's good enough for me. She didn't say anything. Her mom just got shot. Dad's in jail. The kid clams up. And the end of the case. That's the end of the case. Okay? The kid goes back to the same situation, the same family where the abuses occurred to Mr. Delgado and to her. That's the end of that case right there. And who knows what that child's going to be a product of in the future because of all the abuse that's going on. We weren't disputing any. We saw the video, ladies and gentlemen. They didn't need to bring an expert to say there was gun residue, okay? Nobody's disputing that. Nobody's disputing the shooting. We're disputing why it was shot. Why did he shoot? Okay, that's the whole issue. Do you need to take a look at this? We have instruction. The judge thought it weren't merit for you to take a look at. Okay, that's why it's on here. There's evidence to back it up. If there was no evidence, we wouldn't get this instruction. So we have evidence. Take a look at it. The state has to disprove it before you get to a guilty verdict. Okay? They didn't put on any evidence to disprove it. They're going to try to argue it. What the lawyers say is not evidence. Okay? What lawyers say up here is not evidence. It's what comes out of that witness chair. Okay? Whoever's up there. All right? You heard Erica's cousin say she had it on speakerphone, and I could hear Billy was calling, where it said, you know, it's gonna be your last birthday. When Erica testifies, what does she say? Go drop off the kid, he straps her in, comes over to my car and says, it's gonna be your last birthday. So they didn't get that story straight, all right? Because there's two different versions, all right? So it's different. And why would he say that? Why would he, if he wants to kill her? I mean, just do it. Could have done it right there when he dropped off the kid. Why didn't he do it? Because it's leave the house. I don't care. You know, they're stuck in traffic. They're trying to exit so they can drop her off going to San Antonio. What does she do? So he dropped me off so my kids are safe. It's not about your kids being safe, okay? It's about her. All right? It's unfortunate that she got shot. It's horrible. Billy told you. I regret it. You know, I didn't want to shoot her, but he had to do it to protect his daughter. Right? In his mind, it was just that moment. And I told you during voir dire, I said, if I could judge you for your worst 5 minutes of your life, you know, what would be my verdict on you? All right? And that's what you're going to be doing to Billy. 5 minutes when you should be considering the 4 years that we're together. All right? Take a look at the entire picture. Don't focus in on what they're trying to show you. And they're going to show you gross things and bad things, and they say all these things. Do you really need to get those issues proved? I mean, really, it was a shooting. She's injured. She was the wife. They've already done that. Get to the good stuff, okay? Show me how you disproved that the little kid was not abused, that he was trying to protect her. Show me that. They're going to have words. They're not going to have evidence, okay? No evidence. So they can't disprove that. And because of all that, you have to find him not guilty because they can't disprove it. It's their burden, not mine. I raised the issue. They needed to put up evidence. They didn't do it. So it's a verdict of not guilty. That's the reason you get to not guilty. Not because there was no weapon, not because they weren't dating, not because of the other issues. It's because of that. Okay? And all of this was focused toward a prosecution, and it's more vindictive. I mean, nobody does that. Those are horrible pictures. To be able to show, to come back, look what your dad did. Okay? They were praying for Erica. She made it. She survived. You know, but part of the Lord's Prayer is, you know, forgive me for my sins as I forgive those who trespass against me, right? So in this, okay, Mr. Delgado's already been punished for a lot, all right? A lot of abuse, a lot of just toward himself. He had to protect his daughter, and he acted, okay? Make the state prove all the elements of the offense, which includes now the justification. Can they disprove it? Did they put up any evidence? They didn't put up any evidence, okay? So be looking at that. They're gonna put on some more stuff, say some other stuff, but remember what lawyers say is not evidence. It's not. So in your back of your mind, when he's talking about there's no justification, make him go back and say, that was my evidence. So you can analyze that. Check with your notes, okay? And part is for the Delgado family sitting over there. And Mr. Delgado, we thank you for listening to our case, okay?
proceed, Your Honor?
Yes, please.
Thank you. Good morning, ladies and gentlemen. Defense just came up here and told you he's not going to show you any gross pictures. He's not going to do any of that stuff. Ladies and gentlemen, these pictures that we're looking at, that the defense calls gross, are the result of what his client did that day. These are the results of what Billy Delgado did to Erica Torres as she drove up, innocently unsuspecting of the assault that she was about to suffer. I'm sorry that he thinks this is gross, but this is Erica's life now because of what the defendant did. Now, he said his client's been through torment, that he's been through a lot. What has Erica been through? Billy Delgado's a healthy young man. He can walk, he can talk, he can jump, he can run. Erica fought for her life. She has bullet holes to remember every single shot she received from him. And then he told you they brought words. That the state only brought words, that we didn't bring evidence. Ladies and gentlemen, we brought a mountain of evidence. We brought a confession. He even told you on the stand, I did it. He confessed to every single element of the offense. And I want to bring your attention, if you could all grab your jury charge, please, and let's turn to page 5. If you look at that top line, it says, under the justification, because this is what they're arguing. He's saying that they have a justification. If you look at that top line, under the circumstances, as the actor reasonably believes them to be, and pay attention to that word, reasonably believes, the actor would be justified in using force to protect himself against the unlawful force he reasonably believes to be threatening the third person he seeks to protect. Now, reasonably believes. To reasonably believe, you must be able to use what? Reason. I asked him about shooting Erica, I blacked out. When I asked him about shooting her multiple times, do you remember? I don't remember. I can't remember. He conveniently blacked out. He conveniently doesn't remember. He remembers being in the apartment, and then he remembers the cops showing up. So where was he able to formulate this supposed reasonably believe? Where was he able to use his reason when he's conveniently blacking out throughout this entire process that he can't recall? Ladies and gentlemen, it's an excuse. This is a lie. Another lie by the defendant. Just another excuse to justify his actions of what he did to Erica that day. Just the same way he made up the lie about this supposed sexual assault against his daughter by Uncle Louis. The only person that's ever cried wolf about that is the defendant. He's the only person, because Emmy's never told anybody else. She's never told anybody else about it. And let's just say, for the sake of argument, that you see reasonably believes, you need to prove and, because that's the next word. The next word means that reasonably believes to be threatening the third person he seeks to protect, and. So you need to do both. You need both for the justification of defense of third person. So, and the actor reasonably believes, so again, he's got to use reason, but apparently he was blacked out through this entire process. Blacked out because he couldn't recall what he did. He couldn't remember thinking about what to do or how he did it because he was blacked out. The actor reasonably believes that his intervention is immediately, at that point in time, immediately necessary to protect the third person. The third person, Emmy, who's in the apartment upstairs, that he left Emmy with his roommate. You saw Estrada take the stand. She said Billy dropped off some toys and he told Emmy to play and for me to watch her, that he was gonna go talk to Erica. There's no immediacy. Where's the immediate danger? There's no Uncle Louie, the supposed cry wolf that's outside waving, "I'm here, Billy, I'm here." He called Erica over to the house. He told her, "Get here now, come pick up Emmy, I can't do this no more." Why lure her there? If you're gonna do the right thing, call LPD. Do what a normal person would do. Call the police or say, "Hey, Erica, look, I'm not gonna give Emmy back. We need to figure out what to do about this, okay? I'm gonna keep her. I'm gonna keep her with me. I'll give her back to you after we talk to the police." There was no immediacy, ladies and gentlemen. There was no immediacy. So this doesn't apply. And then even then, when the issue of the application, turn to page 6, please. When the issue of the application of defense of a third person is raised, the burden of persuasion is on the prosecution to disprove the justification beyond a reasonable doubt. And defense told you we can't disprove that we can't disprove that beyond a reasonable doubt. Ladies and gentlemen, it's like I told you in Fort Dyer. This is common sense. We use common sense every day. Every day. You heard the defendant. I blacked out. I blacked out. I blacked out. There is no evidence for his reasonableness. There's no immediacy. Again, just another excuse. So let's talk about what this case is really about. Like I said, defense would have you believe that Billy did this because he was triggered by what happened to his daughter. Well then why Erica? Why shoot Erica? She didn't do this. If you were triggered by this, she's not the one who abused Emmy. If this is supposed incident that happened pushed you over the limit, she's the wrong person. Why not take the proper measures like I just told you? Call the police. He bragged about his family being in law enforcement, how his grandmother was the captain of police. If that's the case, then you know police will do a good job, right? You know they'll do their job if you just call and take the proper measures like a normal person. Two wrongs don't make a right. Two wrongs don't make a right, ladies and gentlemen. He doesn't get to take justice and be the judge in this case. What he did is not justified by any circumstance. What he did to the mother of his child. And that case was closed. There was no evidence. There was no outcry. The child was interviewed by a trained professional in a controlled environment, in a comfortable situation where there was no time limit. And Investigator Vaquera told you, the child never outcried to any abuse. They gave her a doll to even say, has anyone ever touched you in any of these places? She never outcried. They gave her an anatomical drawing where it shows the outline of the human body. And they ask, do you know your private parts? Are these areas that no one's supposed to touch you, right? And has anyone ever touched you here? She never outcried after all the opportunities that she had. So of course the case was closed because that was just an excuse, a lie that the defendant made up to shoot and to try to kill Erica Torres that day. Defense would have you believe that Billy is a victim of violence. He's a victim of violence based off a 2-minute and 30-second video. A self-serving video. I'll have you at that. Ladies and gentlemen, if I go home to my wife, I know all the buttons to press. I know what to do to upset her. And if at that point in time, after I've riled her up, and I say, leave me alone, hold on. Come on. That was a self-serving video. Took ownership. She said, I need it. Well, why didn't you try exiting the vehicle? It was moving. My kids were in the back. And why were you so concerned? Because if I missed my arrest, I'm sorry, ladies and gentlemen, yes, she was upset. She was upset because she was being held against her will when the defendant had told her that he would take her to court in San Antonio. But in the video you hear him say, we were late, we weren't gonna make it anyways. She still made it that day, even after getting dropped off, or she didn't get dropped off. She jumped out of the car while it was in between two trailers and walked to the truck stop, waiting for her mom to pick her up. And you saw in the video the defense like, no, please, yeah, I'm tired of this. And what does he do? He looks down to make sure that he's showing his face. Y'all saw him, he looked down. And then, oh, we're gonna crash. What does he do? Afterwards, he pulls up the phone, he's like, all right, let me take it off selfie mode, let me close it. Yes, he was very concerned about crashing while trying to record a video after he was starting a fight, after he was fighting with Ms. Torres, and she was upset because she didn't want to get arrested. I don't blame her. I don't blame her for not wanting to get arrested. Nobody wants to get arrested. And meanwhile, being held against her will, right? Because she couldn't get out of the moving vehicle. Defense would have you believe that Billy did this because he thought he needed to protect his daughter. Ladies and gentlemen, we already talked about this. There was no immediacy. There was no threat. Emmy was upstairs, locked, or not locked, but in a room with the door closed. I'll have you, because Erica Estrada she said on the stand that the door was closed while she was in the room with Emmy. The front door to the apartment was closed, and Billy Delgado walked outside, apparently conveniently to his benefit. He was blacked out, but he told you, I always carry my gun. I always have my gun. It's small enough for me to carry it. I'm not a convicted felon. I can carry a gun. Ladies and gentlemen, where's the immediacy? Erica didn't rev her engine and pull up. No, she's just pulling up nice and slow, ready to pick up Emmy. And what does she hear? Bang, 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 bang. Yes, Mr. Delgado felt threatened. Ladies and gentlemen, common sense. And most importantly, he called Erica to come over. That's what you need to go back to every single time. He called her there. It wasn't her day. It wasn't her time to pick up Emmy. Emmy was supposed to get picked up on Sunday. It was his visitation. But the defendant lured her there. Why? Because he wanted to ambush her. He wanted to attack her and knew that she wouldn't stand a chance, that she wouldn't suspect it. He wanted to kill her. Like I told you, this case is about choices and consequences. We all have free will to make choices. You heard Sharon Estrada. Billy was making pancakes that morning. He looked at peace. He looked at peace. Ladies and gentlemen, if you're upset and if Emmy told him this the night before, why not call PD that night? Why not call Erica that night? The moment you just got told that when he claims that his daughter, she jumped in my arms and she was crying. Get the phone. It's not like LPD only works 8 to 5. Call her mother, let her know. I called the police. I just got told this. No, ladies and gentlemen, because that didn't happen. Erica testified, Billy called her to come over to his apartment to immediately pick up their daughter. He told her, get here now. She told you she was at a friend's house. She dropped what she was doing because she said, Billy told her, get here now, come pick up Emmy. There was no immediacy. Billy created this situation. He created the situation he wanted. He made a plan to execute Erica Torres. What did Dr. Medeiros tell you? When we asked him about serious bodily injury, all the different definitions, he said, she did everything but die. So we met serious bodily injury. She lost her blood volume. She will have difficulties for the rest of her life. And she will need to be monitored. Because she will never have a normal life ever again. But at least she can walk normally, or look like she walks normally. Use your common sense, ladies and gentlemen. We brought you the pieces of the puzzle. Remember? I said we were going to bring you the pieces of the puzzle, and it may not be a complete puzzle, but you'll be able to make it out. We brought you the videos, the shooting. We brought you the interview. Look at that video. There's no remorse. He looked like nothing. You know, instead of saying, how's Erica? Is Erica okay? Is Erica okay? Instead, he's like, look at my rap sheet. Look at her rap sheet. I don't got nothing. She's been arrested. In his eyes, he thinks of her as less than dirt. Look at the way he treated her that day, the mother of his child. He had the opportunity. Billy Delgado called Erica and ambushed her that day. So we've brought you the videos, we've brought you the opportunity that he had, we've shown it to you. The weapon and the casings, all 10 casings. We didn't just bring you the casings, we brought you all of them. All 10 opportunities he had to kill her. The confession, he told you he did it, he told you here to your face that he did it. Not only did you see that, he said, I did it. I shot the mother of my child. I'll deal with the consequences. He told you on the video when he was arrested, and he told you here in court on the stand. You saw her serious bodily injury with Dr. Medeiros. And they were still married the date of the assault and share a child. So we've proven our case. We've proven that on or about June 1st, 2024, in Webb County, Texas, the defendant, Billy Delgado, intentionally, knowingly, or recklessly caused serious bodily injury. Remember, I told you in voir dire, intentionally, go up to someone directly, point a gun at them, right in front of them, boom. That's intentionally. Knowingly, you see a group of people together, you shoot, you know you're gonna hit them if you're aiming at the crowd and they're all jam-packed together. And I said recklessly. When I explained recklessly was that you can appreciate the standard, but you do a gross deviation from it, regardless of the outcome of your actions, right? So even if you think that Billy Delgado says, well, I was just shooting at the car, I wasn't shooting at her. You shoot at a car with somebody in it, you're disregarding the fact that they could get hit. You're disregarding the fact that they could die. You're disregarding the fact that they could get seriously injured. And he did all of those. He intentionally shot at the car, he knew she was going to get shot, and he disregarded that fact when he recklessly shot at her in the car. So all of those three intentional elements are met. And used or exhibited a deadly weapon. A firearm, automatically a deadly weapon, and he also admitted to you, yes, I used a deadly weapon on the stand. During the commission of the assault, namely a firearm and or a G3C 9mm Torres. This is what he used that day, ladies and gentlemen. Not only what he used in the firearm that he was carrying, this is the one that he likes to carry, right? As he told you that he always carries a gun. But he was also accompanied by its two buddies, 2 loaded magazines. Ladies and gentlemen, he had one intent that day. It wasn't to talk to Erica. He wanted to kill her. He wanted to hurt her. He wanted to remove Erica from Emmy's life for his own personal, selfish motives. And like I said, we've satisfied the family dating relationship. You've heard about their entire relationship, right? You know the truth. Remember in voir dire, I told you, can we know exactly 100% exactly what happened that day? No, right, I told you? Because the only way you know is if you were there, if you saw it. Ladies and gentlemen, not only did we show you the acts of Billy Delgado that day, we brought the crime to you. You saw it with your own eyes. You all saw the actions, the lack of remorse. At no point was there any hesitation, and you'll see the video, play it as many times as you want. She pulls up, and without hesitation, he points his firearm and just starts unloading, one after the other. He's not moving, and I know that there was some argument by defense, well, if he wanted to kill her, he could have killed her. Ladies and gentlemen, if this is the car, he was right there in front of it. He was trying his best to aim. He had a mission that day. But what do we have? We have Billy Delgado, still hiding behind his excuses. I blacked out, or I did it for my daughter. Which one is it? You can't have both. You can't have both, ladies and gentlemen. I did it for my daughter to protect her. Okay, well, then you did it? Well, no, I blacked out. Those are completely contradicting statements. That doesn't make sense at all. You did it because you wanted to protect your daughter, but you don't remember doing it because you blacked out? You know why that doesn't make sense? Because it's a lie. It's an excuse for his actions. His own mom told LPD. She testified. She didn't believe Billy. She doubted him. She told LPD, there's no way. She told you on the stand. Yes, I said, there's no way this could have happened to Emmy. She would have told me. Emmy's a talkative child. Well, if she's a talkative child, of course she would have told her. She would have picked up on it. She even told you, yes, I check her underwear when she comes from her mother's. Ladies and gentlemen, she said that on the stand. Your own mom doesn't even believe you. And she tried to stop him. You heard her, that she was talking to him right before he did it. Was he blacked out? Or was he using reason when he talked to his mom? Because he told her, watch this, and then he put his phone in his pocket and boom, 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 boom. But he was blacked out, like he told me, right? He was blacked out. No, ladies and gentlemen. He was trying to execute his own motives. He had an agenda. He had a plan to lure Erica there and execute her. Sharon Estrada, she talked about the box of toys. But I want to talk to you about how, did you hear how she said it? She said it on her own. He looked calm. He looked at peace that morning. If he was so triggered, if he was so bothered by what he heard the night before, how are you going to be in the morning looking calm and at peace? I would be ringing the phones. I'd be ringing the bell. I'd be at LPD banging on the door saying, open up, we're going to talk about this. And I'd be there with my daughter saying, something happened. Remember in Fort Dyer, when we discussed unhealthy relationships? I asked you, I talked to you all about unhealthy relationships, and we discussed how, yes, maybe we or people we know are involved in unhealthy or toxic relationships. And I asked you all, I said, if someone chose to stay or if they were part of an unhealthy relationship and they suffered abuse, is that abuse justified? And you all took an oath and you all said, no. Just because somebody is part of an abusive relationship or they were part of an abusive relationship, that doesn't mean that their abuse should go unpunished, that it should be allowed. You all said that and you all agreed. And that's why we're here to hold Billy Delgado to his actions. It is time for him to face his consequences. Ladies and gentlemen, Erica Torres, she fought for her life. She fought for her life to be here to tell you her story. All 363 days, she fought for her life so that she could have her day in court. And she could come and she could take this stand and tell you about the pain, the suffering, and the actions that Mr. Delgado caused to her. Multiple individuals testified. They said that they believed she was going to die. Officer Luis Castillo, off duty, told you, I was pretty sure she was going to die in front of me. Dr. Madero said, if she did not know, I didn't want to die, she was going to die. And let me remind you about something. Erica Torres is not on trial. The case is called. The victim is not on trial. And we are here did to her. That is why we're here. We're not here for the state of Texas against Erica. And she took the stand. And yes, like my co-counsel told you, we heard their dirty laundry. But you know what? I'll tell you something that she did. She owns it. She takes it. She takes accountability for what she did. She was on probation for what she did. She takes accountability for her actions. But you know who doesn't? The defendant. Because lie after excuse, his actions he still believes were justified. No, ladies and gentlemen. You heard when I asked his tia, his aunt, I said, nobody deserves to get shot, right? 10 times? Yes, I asked her, no woman deserves to be shot 10 times? And she agreed. Nobody deserves that. Nobody. Billy Delgado made his choices, and now it's time for him to face the consequences. So, when I'm done here, you'll go to the back. You're going to turn to the verdict form, and it says, we, the jury, find the defendant, Billy Delgado, guilty of aggravated assault, causes serious bodily injury with a deadly weapon to a family member, felony of the first degree. And you will sign right there, under guilty. Thank you, ladies and gentlemen.
Members of the jury, I'm going to excuse you with the exception of Mr. Pedroza and Mr. Nunez, if you would stay with us momentarily. I need to talk to you all outside the presence of the other folks. Ladies and gentlemen of the jury, don't begin your deliberations because they may have some stuff in the jury room. I'm going to let them come in there and get whatever they left, and then as alternates, they're going to be excused. So once they leave, you begin your deliberations and only discuss the case when all 12 of you are in the room. This verdict, if those two jurors would stay with us momentarily. The alternates on the case, I appreciate your service. With our there's a new law that says what I'm supposed to do is put you in a closet and keep you in the closet until the jury reaches a verdict. But I don't want to do that. It was a short enough case that I don't think we'll need you. So thank you for being here. We appreciate it. Your time was not wasted. Everything I told you earlier about discussing the case is now lifted. Sometimes lawyers like to talk to you. You're welcome to talk to them, or you're free to go. Thank you very much, and go get your stuff. All right, we're in recess. So you can see you in the courtroom.
Check, check, check.
of this crazy music, I'm gonna go ahead and just switch over to Court TV that has both verdict watches, and we'll just watch several Court TV's trial highlights. Tired of the jazzy music.
And I'd be there with my daughter saying, something happened. Remember in Fort Dyer when we discussed unhealthy relationships? I talked to you all about unhealthy relationships, and we asked you all. I said, if someone chose to stay, or if they were part of an unhealthy relationship and they suffered abuse, is that abuse justified? And you all took an oath and you all said no. Just because somebody is part of an abusive relationship or they were part of an abusive relationship, that doesn't mean that their abuse should go unpunished. Hold Billy Delgado to his actions. It is time for him to face his consequences. Ladies and gentlemen, Erica Torres, she fought for her life. She fought for her life to be here to tell you her story. All 363 days, she fought for her life so that she could have her day in court and she could come and she could take this stand and tell you about the pain, the suffering, and the actions that Mr. Delgado caused to her. Multiple individuals testified. They said that they believed she was gonna die. Officer Luis Castillo, off duty, told you, I was pretty sure she was gonna die in front of me. Dr. Madero said, if she did not receive medical help, she was gonna die. Erica told you, I was trying to get to the hospital. I didn't wanna die. Kayla told you, Kayla de la Cruz, she told you, she needed to get to the hospital. She was gonna die. And let me remind you about something. Erica Torres is not on trial.
This is called the state of Texas versus Billy Delgado. That's what this case is called. The victim is not on trial here. She is not on trial. Why? Because she is the victim in this case. What did to her.
That is why we're here. We're not here for the state of Texas against Erica. And she took the stand. And yes, injury. But you know what? I'll tell you something that she did. She owns it. After lie, after excuse, his actions he still believes were justified. No, ladies and gentlemen. You heard when I asked his tia, his aunt, I said, nobody deserves to get shot, right? 10 times? Yes, I asked her, no woman deserves to be shot 10 times? And she agreed. Nobody deserves that. Nobody. Billy Delgado made his choices, and now it's time for him to face the consequences. So, when I'm done here, you'll go to the back. You're gonna turn to the verdict form, and it says, we, the jury, find the defendant, Billy Delgado, guilty of aggravated assault, causes serious bodily injury with a deadly weapon to a family member, felony of the first degree. And you will sign right there, under guilty. Thank you, ladies and gentlemen.
Members of the jury,
And with that, the end of the state's rebuttal argument. Such passion there coming from the prosecution. Let's bring in our guest for this hour, joining us from Atlanta, Georgia, criminal defense attorney Josh Schiffer. Josh, what rating do you give that kind of a closing in front of this jury?
I'm awake again after the necessary nap because that was just entirely too much.
Okay.
If the state's got a gimme, a ringer, a home run, hit it and do awesome. Stand up, be proud, empower that jury. You're doing the right thing. You're fulfilling your duty, your obligations. It is a great day to be a Texas prosecutor. Be the paragon of success and professionalism. You don't need to put on a tabloid talk show closing like you want to see on a late night TV drama. No, man. So other than that, I think the state's done a really good job. I don't like the performative theater. I understand he wants a sizzle reel, and I get that. But this isn't that case. I don't think he moves the needle, and if anything, overperforming on behalf of the state benefits the defense when it comes to the mitigation. Because look, the state just doesn't win. It makes fun of you. It grinds you. It's a sore winner. And I know a lot of people are gonna, cheer the state for taking their win and parading it around. But that's not what juries want to see necessarily. So I love the work the state did. They just need to shorten it up, get it done. I've gotten so many texts over the last 15 minutes from professionals going, when is this guy gonna sit down? Not his best hour.
Okay. Josh didn't like it. That's the thing. When someone goes all in, you either go all in or you don't. And that probably, there were some jurors, I think he probably hooked, and others that he didn't. And to Josh's point, the risk you take is the ones that you don't hook. It can be nails on a chalkboard if it goes on too long.
Right.
But
I think he emphasized what he had to in terms of this. We talked about the sentencing that is ahead in a case like this. These jurors having to figure out what the range would be.
This is all about the sentence.
I think
probably,
this is, something that could hook some, but to Josh's point, could have been overselling it, and, the defense will contend with that.
Yeah, we'll see. So they're deliberating there in Texas. We'll keep our eyes on that courtroom. We're deliberating. They are in Washington in the Ali case. And also in Colorado. Kelly Craft's going to be joining us on the dentist case. But coming up next, finish one, move to another.
Move to the next.
We've got another trial. This one out in Montana. We don't normally have a ton of trials out of Montana. And this one is fascinating. It's a murder trial. And at the base of it, a piece of returned mail. We'll fill you in right after this.
Matriarch of the Adelson family gets arrested.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot. Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind Murder Trial. Live coverage begins this August on Court TV.
Court TV Live. Let's turn our attention now to a new live trial that we are watching together out of the state of Montana.
Opening statements are underway in this trial that we're calling the returned mail murder trial.
Yeah, it's interesting. Defendant Jordan Palmer is claiming self-defense after he shot and killed his neighbor in April of 2024. He says he was putting a piece of mail that he had found on the ground back in the mailbox of his neighbor, Stephen Campbell.
Now, that's when he says that Campbell started accusing him of stealing and began attacking him, but police say that they saw something very different on the video of this incident. Before we get you into court, here's a look at the case against Jordan Palmer.
It was a fight over a piece of mail that ended the life of 45-year-old Stephen Campbell near Bozeman, Montana in April of 2024. First responders found him lying on the pavement with multiple bullet wounds, a Glock 19 on the ground above his head. Standing over Campbell's bloody body was 44-year-old Jordan Palmer, a neighbor. Palmer told officers at the scene, quote, "This guy just attacked me. I shot him." According to Palmer, he had found a piece of mail on the ground and went to the address to return it to the mailbox. That's when he said Campbell showed up, accusing Palmer of breaking into cars, and when Palmer denied it, he says Campbell started swinging. Palmer's charged with deliberate homicide, a capital offense, and could spend the rest of his life behind bars.
Let's go into court now for the start of the state's opening statements in this case.
Good morning, ladies and gentlemen. Thank you for your patience the last few days. I'm sure that there's some anticipation in moving forward at this point, so we do appreciate all of your time. On April 19th, arrived as an open, silent line. No one was there. The caller hung up, and as is their protocol, dispatch called that number back. The caller that he did and said that he had shot a man who, in his claim, attacked him. And you'll hear that the man that was shot accused Mr. Palmer of trying to get in someone's vehicle. I anticipate you'll hear on that call that Mr. Palmer claims that man verbally threatened him and was swinging at him. And in response, Mr. Palmer fired a gun at him 7 times. He pulled the trigger 7 times in response to his claim that this man threw a cigarette down, verbally threatened him, and swung at him. That man was Stephen Campbell, who was 44 years old at the time. And this occurred outside of his home. It was technically in front of 808 Mantle, which is this orange dot right here. Stephen Mantle lived at 807 Mantle Drive. While Mr. Palmer remained on the phone with dispatch, officers and medical were responding to the scene because he indicated that Mr. Campbell, who he didn't list by name, but that a man was lying on the ground, responded to 808 Mantle. He observed Mr. Palmer standing in the road and but still breathing. Only moments after Officer Eichen arrived, Officer Palmer lie on the ground on Mr. Campbell. Officer Eichen observed immediately 2 visible bullet wounds, and during this time, Montana Highway Patrol also arrived along with Officer John Hughes and began securing the scene and addressing Mr. Palmer, who was lying on the ground not very far from where Mr. Campbell's body was lying. You'll hear testimony from Officer Eichen and Officer Damon Turnquist describing the actions that they took and the observations that they made on scene. You'll also hear testimony from Officer John Hughes, who arrived and is the one who actually took Mr. Palmer into custody. He'll describe finding an extra loaded magazine in Mr. Palmer's pocket. And he then transported Mr. Palmer from the scene to the Belgrade Police Department station. Mr. Campbell was addressed by medical on scene. He was still alive. He was transported to Bozeman Deaconess Hospital, where medical staff continued to try to save his life, and unfortunately they were unsuccessful. During this time, Detective Juan Cervantes was contacted and responded to the station to try to make contact with Jordan Palmer. Detective Cervantes will describe to you how he then proceeded to the scene where the shooting occurred and walk you through his investigation, the evidence that he collected, the photographs that he took of Mr. Campbell's clothing, all items found on his person. In these photographs, you'll see that Mr. Campbell's clothes had to be cut off of him on scene in order to assess his injuries and try to perform life-saving measures. You'll also see, I anticipate, photographs that Mr. Campbell did have a pocket knife in his pocket. It was closed and it was clipped on the inside of his pocket. You'll hear testimony from Detective Nicole Nelson, who also assisted.
Hey, prosecutor, laying it out for the jury. What is to come in this case? Fascinating case, all over a piece of mail. We'll get you back to Montana in just a bit, but coming up, we'll update you on what's going on in Colorado. The former dentist accused of poisoning his wife. That jury continues to deliberate, along with the jury out in Washington, the jury in Texas. It's Deliberation Day.
Triple Deliberation Day. Don't go anywhere. More Court TV after this.
Court TV Live, I'm Ted Rollins, along with Julia Janae. We're going to turn our attention now to jury deliberations that are underway in the case against James Craig.
Yeah, this is a former Aurora dentist accused of killing his wife, Angela, by allegedly poisoning her protein shakes. Let's turn our attention to someone who has the latest on this case. We have Court TV legal correspondent Kelly Crabb, who's in studio with us. Kelly, the court didn't allow cameras for a lot of this trial, but now we have seen those closing arguments. Tell us the latest with jury deliberations.
Yeah, hey there, Julia and Ted, and it's really too bad because this has been quite the case to cover and to watch and to see what's been taking place. A lot of drama in this one, and the jury began deliberating early Tuesday afternoon. Before they began their deliberations, in the jury instructions, when those were given to the jury, the judge made it clear to the jurors that James Craig has pleaded not guilty to the charges that he is facing. Now, the defense theory is that he ordered arsenic and cyanide at the request of his wife of 23 years, her name is Angela, so that she could end her own life. The prosecution said in closing, though, that Angela Craig played no part in her death.
He spent 10 days killing Angela Craig. And he could have stopped on day 1, or day 2, or day 10. He kept going. Kept going right until the end. Angela Craig was innocent. James Craig is guilty.
Now, we did hear from family members throughout this case who said that Angela was in no way suicidal.
He was charged with first-degree murders, but jurors do have lessers on the table.
They do, and the judge also, Ted, made this clear to the jurors. So if they don't find him guilty of that top count, first-degree murder, the judge informed the jury that they can consider second-degree murder, criminally negligent homicide, as well as manslaughter. Now, that manslaughter charge is in relation to another theory by defense that he did order arsenic and cyanide at the request of Angela so she could end her life. So talking about here assisted suicide. During the closing arguments, Craig, he was seen crying, especially when defense counsel was reading from his wife's journal. In that journal, she wrote about being depressed and how her husband did not love her because she was not enough for him. Here's a bit of the defense close.
You do not know if this was voluntarily or involuntarily ingested. You know, crossed on this, I talked about this. You know, he went home on March 15th. And if you believe this theory, they're blinders, and you gotta believe this timeline, and this is the writing you're gonna believe, that he went home and got this lethal dose. Oh, this is gonna do it. She's gonna die now. But I'm gonna leave all of this stuff sitting up there? It just doesn't make sense. Why don't you clean it up? If you're poisoning her, clean it up.
So you heard defense counsel there making several arguments to the jury that Mr. Craig had no indication, no motive, no anything to really do anything here for that top charge of first-degree murder. They are fine with these lesser includeds because, for instance, on manslaughter it would be the assisted suicide, and part of their theory is that he ordered it because she wanted to end the life. So he ordered the poison because she wanted to end her life. So it's been a really fascinating trial to watch, Ted and Julia, and of course, if there's any movement from the jury, we will bring it to you.
All right. What a defense theory there,
Yes.
Kelly Crabb. Thank you for that report. We'll bring you any updates here on Court TV.
For now, let's head back to Montana. We're watching the opening statements in this new trial that we just started to watch together. It's the returned mail murder trial. The defendant here, Jordan Palmer. Let's go back in, pick up the openings from the state where we left off.
Her role was more focused on obtaining warrants for both of the parties' residents, Stephen Campbell, who lived at 807 Mantle Drive, and warrants also for the home of Jordan Palmer, who at the time was at 703 Mantle Drive, the blue spot there. So approximately a block apart. In part, those warrants were intended to look for evidence associated with the shooting, but also looking for some kind of possible connection between the two men to maybe help understand why this incident happened. And I anticipate you will hear testimony that there was no connection found. There's no reason to believe that these men ever met or had any knowledge of each other. No prior history with each other. The only common thread was the roughly 1 block distance between their homes. You'll hear testimony from Detective Sergeant Ben Martin, who first responded to the hospital while they were still trying to save Mr. Campbell's life. Sergeant Martin also went to the scene and assisted Detective Cervantes and Detective Nelson in gathering and collecting evidence, interviewing neighbors, trying to find out, again, had anybody witnessed this, and trying to piece together the story of how Mr. Campbell was fatally shot and why. One of the neighbors that detectives interviewed was Lori Mashik. Lori Mashik also lived at 807 Mansell. There's multiple units in 807 Mansell, and Lori Mashik lived in a bottom unit that shared a wall with Stephen Campbell. Miss Mashik was home at the time of the shooting. She was in her back bedroom with headphones on, and when the shots were fired, in part because of where she was located and her headphones, she actually thought it was someone knocking at her door, and that caused her to come out and see what was happening. When she looked outside, she saw one man standing and one man lying on the ground, called out to them and asked if anybody needed help. Mr. Palmer responded to that request saying that he was trying, and then she called 911 as well. James Schultz is also a neighbor. He lives at 806 Mantle. So that would be just one over from the 808 Orange.
All right, quick break. We'll get you into that Montana courtroom for the rest of the state's opening statements in our new trial. Stay with us.
Friday night, superstar guards face off as the Indiana Fever take on the Dallas Wings. Then the Los Angeles Sparks look for a win against the Seattle Storm. Coverage begins Friday night at 7. Find Ion wherever you watch. Ion, it's on.
This week.
Join us each morning to get trial ready for the day's proceedings. Plus, deeper dives into true crime stories with our daily spotlight.
Opening statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
I'm going to hop off for lunch, and I will hop back on in an hour. If a verdict for either case comes, I will restart. See you in a bit.